You do see here that the office, I own the law firm Elder Law Guidance here in Richmond, Kentucky. You have contact information, and in fact, the email address you were sent to get the link for tonight's presentation. If you have a question, you want to schedule something with us, you can send information right back to that info at Elder Law Guidance, and we'll get you set up with someone to go further. So, on to today's purpose. We want to try to help you as much as you can understand the look back. Along those lines, there is a lot of people behind the scenes that help me. This is a picture of all the current staff. You have two attorneys there that I've trained to be completely fluent in everything Medicaid, but there's also going to be a dedicated caseworker legal assistant to guide you through the process, as well as some intake teams and other kinds of stuff. What we handle here in the firm is all that stuff listed there at the bottom. I do veterans planning, Medicaid planning, advanced estate planning, guardianship, and probate. So if you have any need for anything, you need a great landscaper, if you need a paint repair person, if you need an auctioneer, I want to help you no matter what you're needing. But if you need legal help, this is my bailiwick. So let's talk about the basics. This will give us a platform for how the 5-year look back works. For a single person, Medicaid, to get eligibility to pay for the nursing home bill right now, the average cost of care in Kentucky for 1 month is $9,600. Now, if you have enough monthly income to pay for that without leaving your family broke and your spouse without anything, you don't need Medicaid. But for the rest of us, 60% of all folks in nursing homes are relying upon Medicaid. The rest are using long-term care insurance, VA benefits, and a combination of other things. But these are the rules. You can only have $2,000 in your assets. Everything in your name maxes out at $2,000. Then you have to do spend down, and that's what we talked about last week or 2 weeks ago. But there are lots of ways around spend down. I hate the idea of spend down because it just wastes your money. But that is the basic rule: $2,000 or find an alternative. At that point, whatever your income is, you must contribute all of your income to the facility, with the exclusion of $65 a month. Oh, I'm wrong. That slide needs to be corrected. It's not 60, it's 65. Then Medicaid will pay the rest of the bill. What they want you to do is sell everything you have, including your house, use that money to pay for the bill, and therefore you have nothing left as a cushion, because $60 a month won't pay for toothpaste, shaving cream, a new pair of slippers, pajamas, all the stuff that we need. So that's the basic rules. Now, if you've given something away, they're going to create a penalty. And on the backside, if you receive anything else at your probate, Medicaid will claw back. It's called estate recovery, and they will seek to reimburse themselves for the benefit they paid. It's the only governmental program where there's a payback. And few states have it, but Kentucky is one of 17 that does have an estate recovery program. All right, so now let's recap what we've talked about on the asset picture in that spin down. Well, first off, in the income, I do need to say one other thing. Sometimes people are told they make too much to qualify for Medicaid. That is absolutely 1000% incorrect. Anyone can qualify. Now, if you make so much monthly that you don't need any assistance, you can privately pay. You don't want Medicaid. But let's say you make $8,000 and the facility still costs $9,500. You still have a shortfall of 15. But every state is allowed to put an income cap on qualifying. Kentucky says if you make more than $2,901, that you do not qualify. But they won't explain to you that what that really just means is you must have a qualifying income trust in order to qualify. So when it comes to income, since anyone can qualify, my greatest concern for you is that you reduce any income bleed. What I mean by income bleed is if you have an IRA or a 401k, you must put those in a payout status. And those required minimum distributions coming into your income are then money that you lost by it paying straight to the nursing home. So they're not doing you any favor. And most of us live under the illusion that this deferred tax benefit retirement plan, 401k IRA, is really going to help me. But if it's all being lost through the income bleed, it's not helping you at all. So my greatest concern is how do we reduce that income bleed, recharacterize your retirement accounts so that you can save as much of that money as possible. The other side of it, what we're talking about tonight, is the asset side. Now, there's incredible savings potential on the asset side, from your house to your actual cash assets. We did talk last time about 8 ways to save the home. So there's no one that should lose their home to Medicaid, but many people do. The other area of savings, the cash side, is that although there's an asset limit of $2,000, if you're a single person, we have to become more creative. But for spouses, you get a couple more exceptions. The person needing care gets the $2,000 rule applied to them. But if, as a married couple, you have jointly $31,584 worth of assets, those get excluded in total and left with the spouse that does not need care at that point. That's called a community spouse. So the community spouse gets to keep the home, community spouse gets a car, the person needing care gets a car, and the community spouse can keep up to $31,584. If you have more than the $31,000 but less than $157,920, then the asset picture, we're just going to say that it's $150,000. The assets would be split 50. Community spouse gets to keep 75. The person needing care is attributed the other 75,000, but is only allowed to have $2,000 to their name, so they have to spend down $73,000. That's a huge hit, especially when you need a cushion. So, excuse me, I told you I wouldn't cough. I always say that if you're a married couple and only one of you is needing care, then we can save 100% of all the money. In this scenario, 150,000 split between 2 of you with a required spend down of 73,000. That's what Medicaid is going to tell you. That's what, if you go to a nursing facility and they offer to file the application for you, they're going to force you through that spend down process and you're going to lose 73,000. If you came to me, I would be able to save you the entire 150 with no $73,000 loss. You can always save 100% for a married couple. Now, what if you have more than 157,920? Then Medicaid's next rule is they require a double spend down. So you still do a 50-50 allocation to each of them. So 157, so that's going to be what, 78,000 and some change to each. So a $77,000 spend down for the person needing care. And then every penny, I'm sorry, I've used a bad analogy. I should say if we had something like $350,000. If we had 357 or $350,000, we would attribute 175 to each spouse. And the person needing care is only going to be able to keep 2,000, therefore spend down 173,000. The community spouse, the one at home, they're going to have to spend down everything above the 157.9. So about another roughly a little under $20,000 for a total loss of 193,000. Now, here's the kicker. Most people at retirement age only have 150 or less total assets between the two of them, excluding the home. But there are quite a few people that are still going to have the 350,000 or above number that we're talking about. And so the government requires the spend down and loss of hundreds of thousands of dollars. And that happens in a very unfair way. Maybe not those of us on this call, but I know that generation or two older than me, my grandmother had life insurance policies, 5 or 6 of them. And she would have 5,000 in this one and 3,000 in that one. All these little bitty insurance policies because they felt that was a safer way to save and leave an inheritance for people than using a bank because they remembered the stock market crash of 1929 and what that meant for the nation. So they try to diversify using little bitty insurance policies. Well, Medicaid requires those to all be cashed in. You can't keep that much cash surrender value in a policy. So those are really bad ways. These spin downs are unfair in so many ways. So let's talk about how you deal with this. Most people think the way you deal with it, if I'm going to be required a spin down of any sort, I'm going to give money away. That's what the 5 year look back is about. Anything given away, as long as it's within the 5 year period, is going to result or be considered a gift and therefore result in a penalty. So, how does the penalty work? At the time of application, Medicaid will ask the question under penalty of federal fraud, have you given anything away for less than fair market value in the past 60 months? Every time I talk about this, somebody's going to ask me, well, I heard it's going to be 7 years. It's not going to be 7 years. In 49 of the 50 states, it's 60 months. It's been 60 months since 2006. It's not going to change. The only appetite for changing this is to lessen it. It will never get higher. California does have a 30-month, a 2.5 year look back. Sometimes people get confused by that. Sometimes people get confused by the 36-month look back under VA benefits. Medicaid has only been 60 and it will always just be 60. The tricky part here is fair market value. So sometimes what will happen is people get confused about the gift tax amount of 19,000. I can give away unlimited distributions of 19,000 to as many people as I know on an annual basis. That is about taxation, has nothing to do with Medicaid. So Medicaid says if you give anything away at all, it results in a penalty, a dollar for dollar penalty based on what its fair market value was. And then there is a formula to convert that over to a time factor. And that's what you get penalized. You get penalized for a period of time where Medicaid will deem you to be ineligible, and therefore they will not pay for the long-term care. So think of it this way. Mom or dad or husband or wife, one of us need care, go to the nursing home. We're already there. We don't have enough money to pay for the bill because my monthly income is just whatever, $2,000 a month, but my care cost $9,500. I'm $7,500 short. But 2 years ago, I misunderstood the rules and I gave my savings account, put it in my daughter's name. So I'm going to be penalized for that and therefore be declared ineligible. So how do I pay for the $7,500 shortfall? Here is Medicaid's answer to you. I don't know. I don't care. It's not my problem, not my fault. So family is really the only place you can turn. You pull together as a family and maybe children help pay for the parents or whatever the case may be. Really what I would want you to do is come to us and let's solve the problem that created the penalty in the first place. And that's very doable. But you're going to have to get some help one way or another because Medicaid will not kick in. Now, if you can't solve the problem altogether, there is a hardship approach to this. And if you can prove through this legal procedure of hearings and then appeals and so on, then you can still get eligibility, but it's an uphill battle. What we really want to do is just understand the way this look back works. So you see the bottom bullet point here on the screen is this $316.88 per day cost. What that number is every year Medicaid updates it with what the current average cost of care is per day in the state of Kentucky. I don't like using the daily number. I just multiply that by the average number of days per month and use the monthly number of 9,636. For tonight's discussion, guys, what I prefer is just to use the term 9,600, round it down a tiny bit. So let's say I've got a car and I gave it away because I can't drive anymore. I knew that the nursing home is in my future, and I give this car away to my grandchild, and the car's worth $9,600. I go apply for the Medicaid benefit to pay for the nursing home. They see this transfer and they penalize me for 1 month, and I don't have a way to pay for that 1 month. That's all the Medicaid look back is. Now, since the car that I gave away was only worth 1 month's worth of care, and I gave it away a year ago, hasn't that month already passed? No. The look back is not forward looking. It's not that I give it away and after X number of months equivalent to the value that penalty has passed. I have to first apply for the benefit before the penalty ever attaches. And so it looks backward and then establishes a forward penalty. So this is going to be really important. We'll use it. Well, I'll go ahead and use an example now. If you came and we went through this sort of planning together, long-term care planning in a legal context, and you had a couple $100,000, my suggestion to you would be create a trust and transfer your assets, the 200,000, into the trust. But at that point, many folks will say to me, but Scott, I'm already struggling a little bit. I don't know that I can make 5 years, so I should not use the trust. That is not at all true. Unless it's absolutely imminent that you're not going to be able to make it more than just a couple of months, I always want to make the trust transfer to the trust. I've found over the years that it's much better to hope for the best and plan for the worst. So I'll always come up with backup plans, but you always hope for the best, because I've seen many people think they only have a few months, and the next thing they've made it 4 or 5 years. So let's say I'm going to go back to a simpler number. Let's say I've got $96,000 in my savings account and I place it into a trust and I do pretty well. I'm healthy for a number of years, but let's say I get 4 years down the road and then all of a sudden I need nursing home coverage. $96,000 transfer is going to result in a 10-month penalty. But if I apply for the benefit, that's when they're going to penalize me 10 months. What if I just waited another 12 months, so a full 5 years had passed since the transfer? So you can see in this little scenario, I've got a choice of waiting 12 months to apply or apply and take a 10-month penalty. Well, that one's very simple, right? I'd rather have a 10-month wait instead of a 12-month wait. It's not the only solution. There's a far better solution in this situation. But you can imagine that it was worth taking the risk to get us down the road the 4 years, even though we didn't make it the full 5, because things like this could happen. What if I receive VA benefits as well? And the VA benefits will help me pay for part of my care. So if I'm receiving $3,000 in VA benefits, which is maximum pension amount, plus I have income of $2,000 a month, I'm $5,000 there toward the $9,500 monthly nursing facility cost. So I'm only short $4,500. We put that 96,000 in the trust, right? So what we would do at that point is pull the penalty, go ahead and apply and get the penalty established for 10 months. You can always cut a penalty in half by a thing called half-loaf gifting. So we transferred that money. The government says that if you'll give money back in monthly increments, not all $96,000 at once, but if you'll just give back enough to cover 1 month's worth of care, that you can double dip. And so I would get credit for $9,600 in month one, plus I would return $4,500 monthly to pay for the nursing home cost, right? So the 9,600 plus the 4,500 means that each month I would get credit of $14,000 against my $96,000 transfer, which means that, and I'm going to round the number off a little bit, that my penalty will only last me 6 months and I would still have $45,000 in the bank simply because I was willing to go ahead and make the full transfer, even though I wasn't confident that I could make a full 5 years. Now, if you understood that, you deserve a blue ribbon and a gold star because that's a lot of complicated math as we're talking through it. If you just understood this amount, you're going to have multiple options if you go ahead and start a process. The sooner you start, the better. But you should not be afraid of the 5 year look back because there are at least three methods to cure any single look back penalty that you could possibly incur. That was just one example of them. So, as I already said, the penalty itself doesn't start until I apply. I have to be in a facility to get that. It's possible to pull a penalty, a 5 year look back penalty, if I'm looking at in home care through the waiver program or the PACE program. But generally speaking, you're going to still have nursing home level criteria. That's called a level of care assessment, where you have to have at least two activities of daily living where you're establishing the criteria. I'm sorry, three activities of daily living. And then the penalty begins to start the month of that application, or there's a couple of other ways you can wiggle that. But good thing about it is the penalty can always be cut in half, and we can always round the penalty down. So I'm going to take a break and look at some of these questions in the chat that you're doing. So what about church contribution? Church contributions do count as gifts. There are some Medicaid workers that I have seen not count them because there is a federal law that talks about a habit of past giving. So if you've had a consistent monthly amount, I've seen some Medicaid workers just turn a blind eye to this. Most often, however, I've seen all church contributions counted against them. If you are going to try to play the card on that, depending upon a person's faith background, sometimes you'll see folks do a lump sum gift once a year. Other groups, religious groups, tend to give monthly donations. You'll be much better off if you have a monthly donation and it's the same every single time. It just seems unfair that you would have to prove that charitable giving was something, but it is giving, and the Medicaid rule very clearly says any gift of any sort, charitable or otherwise, for less than fair market value is a penalty. And so that's usually the Medicaid's going to come down on it. So I wouldn't risk it. What I would do is still use a trust, put my money into the trust and make my contributions from my trust, because I'm going to have other ways to solve the problem of a penalty if I've used a trust. If I'm giving it from my personal checking account, there's no way to get around it. It's going to be kind of a shot in the dark if you got a benevolent caseworker or not. And if it gets scrutinized, you're going to get caught. Cam asked the question, does a single person pay income taxes while in the nursing home? Yes, they do. Taxes don't go away. So when we're talking about, and guys, I want to say this with some level of respect, but also some level of frustration. The Medicaid rules are written in such a sloppy way that they often will contradict themselves. And I've got good friends, some of them even actually wrote the Medicaid manual. My next door neighbor did write part of that. But they want to talk about gross income for the calculation, but then they also look at net income with the other sorts of calculations. So here you have one of those problems. The $65 personal needs allowance is figured based on gross income, but that doesn't work out. If you have to pay taxes, there is no allocation allowed for taxes. So in the end, Uncle Sam's going to get their money, the IRS is going to get paid, Medicaid falls as a second level beneficiary. In the end, for you, it isn't going to make any difference. All you're going to get is $65 in your pocket, period. Now, this is a much more complicated one. Robert says, what if the marital estate is $750,000? You're going to have a huge spend down. That example that I was giving where there's spend downs on both sides, you get a double spend down. Even the community spouse is not allowed to keep more than the $157,000 number I mentioned. So you got 750. What's that end up being? $385,000 attributed to each of you. So 383,000 has to be spent by the person needing care. And then the community spouse is still going to have to spend a little over half of their 385. So it's going to be a big hit unless I'll answer. Thank you for the softball here. What if the marital estate is 750,000? You better go get a trust quick. That's your solution. You got to get that money into the trust, and it doesn't matter if you're inside the 5 years or not. There's a way to take care of all the other stuff, but you got to get that money protected into a trust. I say that and I don't think about the assumption I'm making that you may understand. Here is why a trust works. When I place the money I have into my trust, the government considers if the trust is written the way it's supposed to be, the way an elder law attorney is going to write it for you, is the government doesn't count that trust as money belonging to me anymore. I've isolated myself from the trust. Now, my trustee can still use it for my benefit, but the government won't count it against me. So you're still keeping all your money, and then it can still be inherited by the future generations. It still can be spent for your needs, for your care, whatever the case may be. There are very few restrictions on the trust. So that's why they work. Question: if you have a lot of assets and then you legally hide them from Medicaid, won't Medicaid want to know that you've had 1 million 5 years ago? No, they don't. Absolutely don't care. They will know. They have the right to know. They could ask you, but they could see you have. Let me make this simpler. If I put $1 million in trust 10 years ago and I apply for Medicaid benefits now, Medicaid's going to pull my tax return, and my tax return is going to show where I account for my taxation of the trust. You still have to file a tax form, a Form 1041 for the trust. Another thing to be clear about, we're not talking about a living trust, a revocable living trust. RLTs don't protect assets. They do have a tax benefit and they avoid probate, but they have no protective value. So you have to be using an irrevocable trust, or as the really smart people say, irrevocable, but I ain't that smart. So you use an irrevocable trust. It's going to show up on your tax form, and Medicaid does access your last year's IRS filing. So they're going to see it, but they don't care. They're not personal for them. If you follow them, many of the workers that I work with, they actually care. They understand that you have no responsibility to pay more taxes than the tax laws allow you. You have no responsibility to pay more for your nursing care than the rules allow you to take advantage of. And so they don't hold any grudges. They don't hold any sort of animosity or try to trick you. I have no problem disclosing. Hey, I've got a trust. It's 10 years old. There'll be no trouble whatsoever. I love that you were so forward thinking in that. Do not consider it cheating them out of anything. You're not simply following the rules. I think that catches me up on those earlier questions. Yes, the trust does have to be irrevocable and not revocable. Revocable trust in Kentucky have no value for Medicaid at all. Question is, can you gift to joint accounts or just create joint accounts? Here's the rule on joint accounts. I place $100,000 savings account, and all I do is I go and I add my child's name to it. So now the question is that 50% my child's and 50% mine? It's 100% yours. Doesn't matter if you put 17 names on it, including the butler. The bottom line is, unless you can demonstrate that the other parties, the joint account holders, contributed to that account, making it their money, it is going to be presumed to be yours, the person applying for Medicaid, regardless of anything else. What if it's the other way around? Let's say my daughter's got $100,000 and she adds me to it, and then all of a sudden I need care. Medicaid's going to assume it's 100% yours until you demonstrate, no, she's the only one that contributed to it. And then they're going to make you take your name off the account. because the second rule that kicks in there is who has access to it. So that doesn't help you, doesn't work, can't protect income from pensions. No way to do other than RMD from income bleed. If it is a mandatory retirement payment that you are receiving, there is no way to correct that. Now, if you had something like an annuity, for instance, you could modify the annuity contract so that it pays to your spouse instead of you, and that would save the income. But generally speaking, there are very few ways that you're going to be able to protect any income at all when it comes to Medicaid. Looks like Laura asked the question. You own your home and you have major repairs to do before you sell it, like upgrading the electrical or repairing the roof. Is that allowed? Yeah. Very simple if you just get the concept that your money spent on your stuff is a fair use of your money. They don't have any business telling you you can't spend it on yourself. You can buy lottery tickets if you want to. Medicaid's not going to fuss about that. That's how weird the rules are. You can't give $1,000 to your granddaughter for a graduation gift, but you could go buy $1,000 in scratch offs and they won't care. That's the rule. So any expense on your own stuff is allowable. So let's say this is a legitimate use of money. And say I've got $100,000 in the bank, and that's the only thing keeping me from getting Medicaid. I can take that $100,000 and I can go buy me a brand new Escalade for $100,000. And now I'm allowed to keep that car. Medicaid approves me and they won't do a state recovery against it. Nor do they penalize you for giving a vehicle away. They used to, but they've changed that rule. So I could keep that car for 6 months. I'm not using it. I could give it away to one of my children, and I still have no problem with Medicaid. I don't like that use of money because your car is going to depreciate so quickly when you buy it. So I'd rather see you use a complete protection strategy instead of something more suspect, but just something that's depreciation undervalues that. So we can completely protect it instead of taking a diminutive value. But it works. Very strange rules. So yes, you can upgrade the house. You need to do like that. You're going to sell it and you're going to lose again. So I would seek to do a different method on the sale of the house, but you're thinking correctly. As an FYI, can you place your property in the trust, not just financial? Yes, you can place any real estate in trust. You can place any life insurance policies, any sort of investment account, stock, bond, CDs, anything at all like that. So real property, personal property, all work. To ask another question, will joint owners of a vehicle stop it from being an asset? So let me go through the rules on vehicles. If there's a married couple, each of you get a car excluded regardless of its value. If you're a single person, you only get the one car excluded regardless of its value. And single or joint, additional cars are excluded up to $4,500 worth of fair market value. So I could have 17 cars, each of them worth only $200 each for a total of $3,400, and they're all excluded. You don't need to worry about joint ownership. The only thing I would suggest about joint ownership on a vehicle that is helpful is I always want my clients to dual title any vehicle into the name of somebody much younger. That's got nothing to do with Medicaid. That has to do with probate avoidance. If you have a car in your name, you pass away, you're going to have to go to probate to get that retitled into the heir's name. If you already had your child's name on it as and your child, you need to make it or, not and. For $17, child can be placed on there with parent, and at the parent's passing, the vehicle becomes the child's. No need to go to probate. Steve's got another question. Man, you guys are just all on the questions tonight. I love it. Irrevocable trust. You can't change the beneficiaries later on. No, you can't. As the trust maker cannot modify, trustees can. And if you think that that's going to be a concern for you, what I would do as the drafting attorney is I would put the contingencies that the trustee can follow. You make those very sophisticated, and I don't mean complicated. They can just be fun to put in these other contingencies, if this, then that, or when you have discretion, what you should consider. Need to be thoughtful up front. One of the things that often happens is, divorce. There can be that develops in families, so you can draft with those concerns in mind. But there are things that you're going to have to put within the scope of the trustee to make that modification, not the trust maker. But you can do that. An irrevocable trust. Um, is the ownership of an IRA or an annuity changed? Great question, Lincoln. I'm assuming what you mean by that is, yeah, you've got an irrevocable trust over here. I also have an IRA or an annuity. Generally speaking, the annuity is going to be owned personally, just like the IRA. An IRA, an individual retirement account, can only be owned by an individual. It cannot be owned by a trust. You could unwrap it and put the investment, the amount, the principal in the trust. The annuity could be owned by a trust, depending upon the company that creates it for you. But the companies are going to be very helpful for you. If you say, I want to change ownership, put this instrument, this annuity in my trust, you call them, you ask them, they're going to send you a form and you just do a change. The IRA, you're just going to have to liquidate it. So you're going to ask them to liquidate it. Generally, I do planning with people to do sort of a cost benefit analysis. Does it make sense to liquidate? Are you going to lose more money to taxes or more money in your nursing home planning strategy? If you're going to lose a lot of money on taxes, we're going to stretch that out over a number of years so that it doesn't pump you up to a really high tax rate. So a graduated drawdown is what I would suggest there. So the answer to your question is, if you're going to do something like that, you need to talk to an attorney or a tax planner before you go to the company to liquidate it. But you're going to ask eventually the IRA holder for the forms to liquidate. It's not very different from a transition to a Roth, but you want to do that over time. So federal pension by the husband cannot be protected for either spouse. No, sir, it can't. Unfortunately, just locked in on that. Good question. If your bank account is pay on death to a child, would the need to pay Medicaid upon your death would they recover under estate recovery? It is not going to be recoverable under estate recovery, but the rules say that it is. Okay. The rule says anything owned by the Medicaid recipient at the time of death can be recovered against. But just because the rule says it doesn't mean that practically it can be done, because the only way for them to force repayment is they have to be able to get it through the probate process, the court system, and a lien has to be attached to it. It already paid on death to the child. Child having possession cannot have a lien placed upon you for the debt of another. So again, here's why I said earlier, the Medicaid rules are very poorly written. They say, yes, we can recover, but there's no way to do it. And there's a number of areas that this is true about, but you would be safe in that. The problem with your question, and maybe you just not giving me enough detail, the person receiving the Medicaid benefit who would have to face a state recovery, they're not going to have a bank account that has any more money in it than the $2,000. It kind of sounds to me like you're thinking about a bank account that has significant amount of money. Not that $2,000 is not important, but 30,000. So this is not really the kind of problem that you're going to face. There's not going to be a whole lot of money in an account to be recovered against. Your method would work if there was some money out there. Okay, that gets me to the bottom of the questions. I'm going to go back to a slide or two, and I see that we are kind of up on time limit in just about 8 minutes. So prepare. If you have any other questions remaining, I want to touch on a couple of things. I gave the example of $100,000, a big 5-year look back problem, straight cash. But people can make mistakes in two other ways. Oftentimes, we don't think about a partial gift. So let's just say that Papa had a pickup truck that's worth about $15,000. He kept it in great shape and he wants to give it to his grandson, but he wants to have grandson give a little bit of skin in the game, right? So he said, I'll sell it to you, son, for 5,000. Is it a gift? Yes, it's still a gift because the fair market value was not what was received. He only received a third of its value, not the full market value. So that would leave $10,000 as a penalized, unauthorized transfer and therefore 1 month eligibility. So that happens quite a bit. Another thing that, skip that one because the cash example is exactly what we've been talking about. Um, this slide, a home transfer. This one, something that I see all too often, and I see it, I think, because of just down home logic. We think, I'll give my house to my kids, it'll be okay. They're the ones going to receive it anyway. But the one that really bothers me is I see a lot of attorneys give this example. Now, they're not elder law attorneys, they're general practice attorneys, and they should not say this, but they don't know any better because they are limited in their knowledge. And they'll just say, put a house in your kid's name, it'll be okay. No, I think what they mean is it'll be okay if you make the 5 years. But they're still wrong because here's the problem. I give my house to my kids. 6 years later, I need nursing home care. Yes, I am outside the 5 year look back, no problem. But what's the problem? The problem is the capital gain. If I inherit a house from my father, he gets a full capital gain exclusion. I get the full capital gain exclusion stepped up in basis. So I'm not going to have any taxable gain. However, if my father gives me the house, I'm going to get a huge capital gain. So let's use a very simple scenario because if we're talking about our parents' house, they may have bought a very modest house a long time ago. So let's say in 1978, our, our parents purchased a house for $40,000 and 2 years ago gave it to one of us. And it's currently worth 50,000. I'm sorry, 150,000. So just look at the third bullet point. Current fair market value 150, subtract the original purchase price of 40,000. That means from 1978 until the current fair market value, it gained value of 110,000. Oops. And that is my taxable gain. And the taxable gain on 110,000 is going to be 20%. So 110,000 times 20% means that the giving of your house, because somebody told you that was the way to go instead of going and setting up a trust, is going to cost you $22,000 in taxes. It don't matter. You're not worried about it, right? That's going to be the kid's problem. And that's right. That's exactly what's going to be happening. And the kids aren't going to have to pay it now. The child that received this house doesn't have to pay the 22,000 until later when they sell it. And then the 22,000 comes and they don't know it. It just comes out of nowhere. And most likely they may even not catch it at the time of the sell. And it comes up in an audit later with penalties, interest, and all sorts of other trouble. So this is a terrible idea. I would never, ever have anyone just place the house in the child's name. I don't care about the look back, guys. I care about the taxes because the more valuable the house is, the greater that taxable gain is going to be, and it's really going to bite you. Let me see. Is there anything else? I did have some slides here that talk about other backup plans. I always put at least two backup in plans. Now, I don't tell the backup plan intricacy to the client because backup plans change almost every single quarter, depending on how much money we still have, how much time we still have, all of that sort of stuff. So we can use all kinds of things like notes, caregiver agreements, strategies. Everything can be used to avoid this 5 year look back. Um, Always depends upon your very specific situation, how much you have, how long ago is it transferred, how much time do we have to to use to our advantage. So let me put this slide up here while I go back to the chat and answer one more question that I see. If you've got other questions, please put them in there. But first, let me ask you, think about a Google review for us. If these webinars help you, really would appreciate you doing a Google review. You can simply hold your phone up to the screen and take a picture of that black and white checkery kind of called a QR code, and it'll send you right over to Google. 5 stars, you're done. It'll take you less than 15 seconds. All that does for me is it allows anything I post on the internet to go out to a greater, wider audience. So you're really helping other people get in on free information. That's really all it's good, helpful for. I appreciate you doing that. If you don't want to do that, okay, too, we'll still be friends. Okay. Now back to the chat. What about tuition to grandchildren? Exactly the same scenario. It's considered a gift. Money's already gone, right? It's been paid to the university. There's no way to cure this. We're going to have to find a more creative strategy, but it's result in a penalty. Is not if it was tuition for yourself, fine. But the fact that it's for another person, it was gifting them money to pay tuition on, so it's going to result in a penalty. Asks, who can be the trustee of an asset protection trust? Can be the trustee. Your second half of the question, can I be a trustee for my wife or she be a trustee for me? Yes, you can be your own trustee. The real issue is going to be based upon what's in the trust. So I don't have any problem at all you being your own trustee if the only thing in the trust is your house. If you have cash assets in the trust, then you're going to start losing money one way or another. Now, sometimes you don't have any other option. You'd hire a CPA, a banker, an attorney could be your trustee. Could be any family member, but a lot of us don't have children, grandchildren, anything like that. So you got to search for a trusted individual, even if you hire a professional to do it. If it's a cash asset, you're going to limit some damage, but you're going to have a significant financial loss if I don't take you to be this way by any means. But some people just don't, they're stubborn and they say, I still want to be my trustee. I don't care. Okay, you can, but you are going to lose some value. And you can follow this sort of thinking, because I'm not going to do a scenario on this one, but basically you're just turning the trust asset into a 401k IRA kind of thing where there's going to be a required minimum distribution into your income stream, and you're going to lose that. Overall, the loss would be small if you need care for a short term. If you need care for a long term, you're going to have significant loss. But you could protect the principal. You just won't be able to the income stream that would be required. Kind of rounding off the math here because $9,600, $9,636 per month is almost $10,000. So $50,000 is right around. I'm gonna actually do it. I'll make this a little clearer. Hopefully this will help. 50,000 divided by 9,636 means you're going to get a 5.19 month penalty. But because Medicaid will always round down their penalties, at the 5 month and 20% through the 6th month, they're going to round it back down to the start of the 6th month. So you're really only being penalized 5. But that does not take into the account that you can always cut a penalty in half. So $50,000, a 5.19 month penalty cut in half means that we're going to get that penalty down to 2.6, which rounds down to 2. So a 2-month penalty if you go get help with an attorney. You got to be able to implement the half-loaf gifting method. You see the basics here. $50,000 gifted is going to result in 5 months of private pay. And then you're going to have to go back and reapply with new documentation on everything. You pay for care expenses after the penalty. How do you pay for care expenses after the penalty are in place? I'm assuming that what you're saying is, in this example of a $50,000 I apply right now and they say, oh, nope, you're penalized for 5 months. You are ineligible. but I don't have any money. I'm broke. What do I do? Money's already gone, went to the college tuition, let's say. Medicaid doesn't have an explanation. They don't care. You're on your own. You can take donations, ask the children to all kick in and help. If none of those are available, the nursing home does have the right to kick you out. If you're not able to make payment, they can kick you out and they do kick you out. So you've got to go find a method. Now, there is an exclusion in Medicaid. You can apply for a hardship, but you first have to be exercised a eviction notice, and you can only do that. Well, if Medicaid will work with you a little bit, you could avoid going through administrative hearing process, but generally speaking, the administrative process is going to take you 2 to 3 months. The nursing home will have kicked you out by then. So you're really going to be in a pickle. That's why the penalty is such an effective method for Medicaid, because you're going to lose. Um, I know many people just have had to go home, had to have family members take care of them, wait the penalty out. There is no financial mechanism other than the hardship appeal, which takes so much time that you probably end up losing anyway. But it is an option for you. I don't have my topics picked out for October yet. There is the last September. I thought about going back to VA, like doing the Medicaid stuff, but I'm trying to do things more in a series so that I can give you a deeper dive, but give it to you spread out over a number of weeks. If there is something that particularly interests you, sometimes I do just a standalone thing, let's say on caregiver agreements. I've done series on trusts before. I've given consideration to thinking about just guardianship. Anything that concerns you, if you want to send email to us, I would be happy to a special webinar just for what's on your mind. I always need that help because I kind of get used to it and I don't know what's new and most relevant to folks. So happy to special order anytime you want. Thank you guys so much. I see a few more things here. On a political question, what's the provider tax that affects the amount of Medicaid to be spent and available to Kentucky? Um, Simply talking about the taxes that fund the Medicaid program, never going to impact you, but there is a structure because what happens is it's a federally funded, but state contribution is mandatory, and that's the way they get the taxes to do that. Good to see all of you here. I see a few, like I said early on, see a few repeat people. Nice to see faces that I've talked to a time or two before in these webinars. Hope to see you next time. You are, unless you opt out, you're going to continue to get notices. Send me a message. What would you like to hear? Thank you for giving up a Thursday evening to be with me, and I'll see you next time.